Good evening. I'd like to begin by thanking Debbie and Nels American Constitution Society for inviting me to participate in tonight's event. And I'm honored to join my esteemed colleagues in discussing the court's term. My area of concentration is criminal law and procedure, topical areas which often serve as main courses of the Supreme Court's intellectual feast, to use Robert Bork's phrase while he was seeking confirmation, and of course before his last name became a most unfortunate verb. This term is no different. The justices will hear a number of important cases in the area of criminal justice. To a certain extent, the cases have a certain deja vu feel to them. The justices will be deciding what state offenses count as crimes of violence for purposes of the federal anti-recidivist statute. And believe it or not, Tennessee death row inmate Gary Cohn will be before the court for the third time. He may be back again in the near future. These and other cases are not merely the result of some type of nostalgia on the part of the Supreme Court, on the part of, or at least a part of the four justices that decide to grant cert. Instead, the court is trying to fill in holes in its previous decisions. Questions that may have been unanticipated or instead were expressly or even implicitly reserved by prior cases. And a good example of this is the case of Herring versus United States, which poses an unanswered question of Fourth Amendment doctrine with some potentially important consequences for law enforcement around the country. The case comes out of Coffee County, Alabama, where in July of 2004, a somewhat shady character named Benny Herring came to the local sheriff's office to check on a vehicle that had been impounded. A sheriff's investigator who knew Herring and his dubious background asked a clerk in the sheriff's office to check on whether there were any outstanding warrants for Herring. And when no warrants were uncovered, the investigator then asked the clerk to check in neighboring Dale County to see whether there might be some warrants over there. This time the investigator had paid it, and his clerk was informed there was an active warrant in Dale County for Herring's failure to appear in court. The officer acted quickly on this information, followed Herring as he drove away, pulled him over, arrested him, and then, incident to that arrest, conducted a search, which, not surprisingly, given that this case is now in the Supreme Court, came up with drugs and guns. Meanwhile, back in neighboring Dale County, the clerk who found out, who originally determined that there was a warrant for Herring's arrest, found out that this was all a mistake. The warrant had been recalled by the court, and the Dale County Sheriff's Department had simply failed to update its records. A mistake that was later described as being at least very negligent. Now, all this came too late for Benny Herring. The arrest and search had uncovered these drugs, and he was eventually prosecuted in federal court for methamphetamine possession and for being a felon in possession of a firearm. His motion to suppress the fruits of this search was denied, and he was convicted on both counts and sentenced to a little over 2 years in prison. And his appeal was denied by the 11th Circuit. Now, what makes this case interesting is not the facts. The facts are not in dispute. Instead, it's the lower court's extension of a much debated exception to the Fourth Amendment's exclusionary rule, the so-called good faith exception. Now, as a matter of background, for those who haven't taken constitutional criminal procedure, let me provide a ridiculously cursory statement of the relevant search and seizure law. The Fourth Amendment protects against unreasonable searches and seizures. And as a matter of precedent, it maintains a default rule that requires probable cause and sometimes a warrant before law enforcement can engage in these intrusions. The issue, as you might guess, is what happens next. What happens when the Fourth Amendment is violated? For nearly a century in federal courts and about a half-century in state courts, the principal remedy has been the so-called exclusionary rule, which requires that evidence seized in violation of the Fourth Amendment requires that it not be used at trial against the individual whose rights were violated. Now, several rationales over the years have been enunciated in favor of the exclusionary rule, including the idea that a right must have a remedy, something that I'm sure rings constitutional law to all of you. To allow law enforcement to use the fruits of its unconstitutional behavior would render the Fourth Amendment a most hollow guarantee. Suppressing the evidence seized unconstitutionally puts the parties in the position closest to where they would have been but for the constitutional violation. And to fail to do so, in some sense, delegitimizes the judiciary. It seemingly is riding shotgun in a violation of the Constitution. A second rationale concerns the notion of deterrence, that evidence should be suppressed in order to ensure against illegal behavior by law enforcement. By excluding unconstitutionally seized evidence and possibly scuttling a criminal prosecution, law enforcement is provided an incentive to abide by the strictures of the Fourth Amendment. To be clear, as you might guess, there are strong arguments against the exclusionary rule. Benjamin Cardozo, who, if you're 1L, you may be getting sick of by now, once quipped with derision, "The criminal is to go free because the constable has blundered." Among other things, opponents of the exclusionary rule argue that the group that suffers from the suppression of evidence is not law enforcement alone, but society at large, which has an interest in all relevant evidence being presented in court, and of course, ensuring that the guilty do not go free. Opponents claim the exclusionary rule sweeps too broadly as well, and has only marginal value as a deterrent. Over time, the exclusionary rule has been pared back by the Supreme Court, with the Fourth Amendment now subject to numerous exceptions, making it look a little bit like Swiss cheese, including the notion of good faith. In 1984, the U.S. Supreme Court in United States v. Leon held that evidence seized by law enforcement pursuant to a facially valid search warrant need not be suppressed when it is later determined that the warrant was not based on probable cause, as determined by a magistrate. And in a companion case, Massachusetts v. Shepard, the court came to the same conclusion with regard to technical errors by the issuing magistrate. In these cases, the Supreme Court emphasized that the main rationale for excluding evidence in the first place was deterrence, deterring unlawful police conduct, not rights vindication. And because the police in Leon and Shepard had relied in good faith upon the actions of judges who were presumably undeterrable, I'll leave that up to you, there was little, if any, behavioral value in applying the exclusionary rule, but all the costs associated with not allowing perfectly legitimate, otherwise legitimate probative evidence to be admitted in court. A decade later, in a case called Arizona v. Evans, the Supreme Court reached the same conclusion and applied the exception to situations where law enforcement relied reasonably upon a court employee's representation that a valid warrant existed, something that looks almost identical to the Herring case, when in fact the warrant had been quashed. The error, of course, there was by a court employee, and that is a key component or a key question here in this case. In Evans, the court found that there was no deterrent value because the error was, again, by a judicial actor, not by law enforcement. And more or less, you can't deter police by punishing them for the mistakes of another branch of government. So now let's fast forward to 2008 and to the Herring case and some undisputed facts. The defendant possessed guns and drugs. His arrest was unlawful, and thus his Fourth Amendment rights were violated by the search that turned up the guns and the drugs. The arresting officer relied upon good faith, upon information provided by a sister agency. That agency had been negligent, however, had not acted reasonably in updating its records, and most importantly for this case, and of course for Mr. Herring, is the decision on whether the guns and drugs are admissible is dispositive. Now, if you read the briefs in this case, the entire question would appear to be deterrence. The Solicitor General's office argues that the exclusionary rule has been limited to where the deterrent purposes will be appreciably further, and the benefits outweigh its costs. Here, the government claims suppression is not warranted because the arresting officer relied in good faith upon a statement by another agency. It would be like telling a student that if he skips school, one of his classmates will be punished. Now, in contrast, the defense, which is ably represented by a constitutional law scholar at Stanford, argue that the good faith exception has no application here. Previous cases all involve situations in which the police relied in good faith upon a judicial representation that a warrant existed. There was no police misconduct in these cases. It was an error by the judiciary. And nothing about the fact that law enforcement agents here were in fact relying upon information provided by another agency undermines this argument. As the defense argued, law enforcement personnel are collectively engaged in the often competitive enterprise of ferreting out crime, and they do so as a group. My question that I leave you with today is this. When law enforcement violates the Constitution, should it be a question of economic analysis, questions of costs and benefits, and ultimately of deterrence? Or instead, is this one a question of rights and the vindication of rights? If it's the former, then maybe we need a little bit more statistical study on this issue. I'm not so sure that everything is fully understood about deterrence and law enforcement. And maybe we need some economists on the court, although I'm sure those who are legally trained would disagree. If it's the latter, then the problem is that the bench and bar is simply asking the wrong question. Thank you very much.
In Federal Communications Commission against Fox Television Stations, Inc., the Supreme Court will review a decision of a split panel of the U.S. Court of Appeals for the Second Circuit. That court ruled that the FCC violated, yes, the Administrative Procedure Act. The Second Circuit ruled that the FCC violated norms of explanation and justification when it changed its long-standing policy of relative restraint in the area of broadcast indecency and adopted a new policy against the use of isolated, crude language, or we'll call it fleeting expletives, in primetime broadcasts on stations licensed by the FCC. Now, this policy change came about in a swirling environment, swirling political and regulatory environment. You may remember some years back, the Bush FCC favored deregulation of rules restricting multiple ownership of radio and television stations. And some of the Democrats in the FCC opposed that deregulation on the grounds that as fewer and fewer corporations purchase more and more radio and television stations, there would be a race to the bottom in terms of content, and that without the hands-on participation of local owners, radio and TV would have no sense of community standards, and indecency would be on the rise. The Bush chair of the FCC, Michael Powell, wasn't interested in indecency regulation, was very interested in, wasn't interested in indecency regulation, was interested in deregulation of multiple ownership rules. But his successor, Kenneth Martin, has joined the Democrats in the FCC and the other Republicans in leading the indecency charge. Meanwhile, in Capitol Hill, Senator Rockefeller of West Virginia has led efforts to enact legislation giving the FCC new power, whatever it needs, to crack down on indecency. In fact, following the Fox case I'm about to tell you about, Senator Rockefeller introduced legislation that would, in effect, reverse the Second Circuit and give the FCC that power over fleeting expletives. So it's an interesting environment. What was getting everybody so bent out of shape about indecency? Remember, we're not talking about cable programs. We're talking about broadcast. And I know that broadcast content comes into your homes and apartments via a cable line, but we're talking here about broadcast station content, content by stations licensed by the FCC. So what was going on? In 2002, Cher used the F word. in accepting an award. Did she get an award? On Billboard Music Awards. In early 2003, Bono did the same thing at the Golden Globes. Later in 2003, that artist, Nicole Richie, was convincing with Paris Hilton at the Billboard Music Awards. And as they were leading up to give an award out, Nicole Richie used the S word and the F word. All this on live TV. Of course, soon thereafter, in early 2004, you'll remember that Janet Jackson and Mr. Timberlake had that famous performance at halftime at the Super Bowl. That involved not a fleeting expletive, but a fleeting image. And then some lesser-known instances. One of the networks wanted to run Saving Private Ryan, with a lot of such language used throughout that movie. And another one of the networks wanted to run a documentary on blues musicians, and there were some repeated uses of, and some isolated uses of expletives. So what happens when a show does this, that's subject to the FCC's control? How does the FCC get involved? The FCC gets involved by receiving viewer complaints. And in all these instances, somebody complained. At that point, the FCC cranks up its adjudicatory machinery and investigates and then adjudicates the complaint to see whether the speech complained about violates the indecency policy. Where did the FCC get the authority to play a role in any of this kind of thing? Title 18 of the U.S. Code, Section 1464, makes it unlawful, quote, to utter any obscene, indecent, or profane language by means of radio communication, and provides that violators shall be fined under the title or imprisoned not more than 2 years or both. The Communications Act, that is the enabling act for the FCC, in 1960 was amended to give the FCC power to impose money fines or forfeitures on violators of that provision in the U.S. Code, Title 18. So there is statutory basis for the FCC to penalize indecent speech by broadcast licensees. Most famously, the FCC used this power in 1975 when a viewer complained about hearing a broadcast of George Carlin's 12-minute 7 Dirty Words monologue at 2 p.m. in the afternoon on a public radio station, WBAI-FM. So the FCC had to adjudicate. Was it indecent, that broadcast of the Carlin monologue on 7 words that you will never hear on television or radio? And I don't know if you've heard that monologue, but there's a lot of repetitive use of the words. That's all it is, really. And in adjudicating that complaint, the FCC said, you know, this is indecent as broadcast at 2 p.m. on a public radio station. And the FCC issued a definition. It says the concept of indecency is intimately connected with exposure of children to language that describes, in terms patently offensive as measured by contemporary community standards for the broadcast medium, sexual or excretory activities or organs at times of the day when there's reasonable risk that children may be in the audience. So that was its sentence about what they're talking about in terms of indecency. Given the time, 2 p.m., given the nature of the Carlin monologue, the FCC ruled that it was indecent as broadcast. A passing isolated expletive would likely not have been ruled against, said the FCC, even if at 2 o'clock in the afternoon, but a 12-minute monologue of continually repeated words was indecent. the FCC indicated that, you know, if the station wanted to put that 12 minutes late at night, maybe that wouldn't be a problem. So that went up to the Supreme Court. The Supreme Court narrowly upheld the FCC's action, finding the Carlin monologue indecent as broadcast. The court said, you know, this is broadcast. It gets less than strict scrutiny. The regulations applied to broadcast. Broadcast is uniquely pervasive in the lives of all Americans, uniquely accessible to kids, and therefore regulations get less than strict scrutiny. The court said the FCC is not trying to ban this, they just don't like it in the afternoon. The wonderful Lewis Powell wrote concurred in the judgment, so wrote a concurrence that said, you know what this is really about? It's about verbal shock treatment. Verbal shock treatment. And that's what the court is talking about today. That's what the FCC is trying to deter through its indecency regulation. Over the next decade, the FCC made no real aggressive effort to do anything much with the indecency power that had been affirmed by the Supreme Court. It wasn't until the end of the 80s, at the end of the Reagan administration, the FCC started saying, well, you know, it's not just the Carlin type stuff, but there could be other words and other graphic content that would violate that big long sentence that I read you a few minutes ago. And they found some programs indecent under that thinking. But again, there was no indication that fleeting expletives would be the target. These isolated, one-time only, Bono-type sentences. 2001, the FCC kind of re-articulated its policy. It said, we're talking about sexual or excretory content, and we're talking about patent offensiveness in terms of whether it's gratuitous, graphic, shocking at the time of day and in the context that it's shown. Again, fleeting expletives didn't seem to be what was being targeted. All that changes when Bono gets on the Golden Globes. And although the FCC's professional staff ruled that Bono's language didn't make it an indecent broadcast, the FCC, the top dogs, reversed the staff and said, no, that was indecent as broadcast. They said the F word's core meaning has a sexual connotation, even when used in a non-literal, intensifying way by Bono. It said that Bono's use of it on a nationally televised awards show was graphic and gratuitous, therefore patently offensive, and the FCC made a point of saying that the network didn't make any effort to use technology to kind of, you know, delayed response time to blip it out. After that, well, the two shows at issue in the Fox case that I'm telling you about were the Cher and the Nicole Richie Billboard music shows that Fox put on. Same kind of thing. The FCC said both were indecent broadcasts, one time only. In the case of Cher, she said about her critics, she used the F word about her critics who didn't like her singing. And the FCC ruled that that was in the category sexual or excretory, it was sexual, and patently offensive for being gratuitous, shocking, no redeeming value. Same thing was said about Nicole. Now, she said she used the S word too, so they said, okay, we've got sexual and excretory, and we've got patent offensiveness. So, the FCC pointed to one interesting thing, and I'll be finished in a minute, but the FCC pointed to some language in that 30-year-old George Carlin case of the U.S. Supreme Court, where the Supreme Court said this: to say one can avoid offense by turning off the radio dial when he hears indecent language is like saying that the remedy for an assault is to run away after the first blow. So what the FCC is now doing is saying the first blow is something we are interested in now. We weren't really interested in the first blow back in 1978. We are interested in the first blow now. That fleeting expletive. We weren't interested in it before, we are interested now. It's going to be considered per se indecent, and we'll give the speaker a chance to rebut that presumption by saying that something about the context makes it privileged in some way. Now, look, what I got to tell you is at the same time that all this stuff about Cher and Nicole was going on, where the FCC was cracking down, the FCC held that the use of the expletives in Saving Private Ryan on network TV, not indecent. And yet the use of the expletives in that Blues documentary was. And so the FCC has been trying to make a lot of distinctions, case by case, saying we're going on context. Private Ryan is one thing, Bono and Cher another thing. So the Cher and Nicole Richie cases went up to the Second Circuit, 3-judge panel. 2 judges said, you know, we're supposed to be prudential and not race to answer First Amendment decisions, so we're going to analyze this on administrative law grounds first. And the majority said the FCC, in changing the old policy and in adopting this new policy against first blow, fleeting, isolated expletives, was arbitrary and capricious under the APA, that provision that you all know and love so well. Section 706, something like that. And the Second Circuit panel went on and on about everything that was irrational, mainly saying the FCC didn't explain why it wasn't concerned about first blow in 1978 and is now, and also showed no real evidence of harm that fleeting expletives are causing. So more explanation, more rationality was required. Those judges, one was a George W. Bush appointee, if you want to know, and another one's a Clinton appointee. The dissenter, Judge LaValle, was a Clinton appointee. He said, I think the FCC did a pretty decent job explaining its change policy. It's worried about a deluge of fleeting expletives, that everybody gets one free or something, and that the FCC's worrying about that as broadcast strives to compete with cable, which we all know is pretty salacious already. So there are going to be more of these fleeting things. The FCC's trying to strike a balance, and the senator said, I think the FCC is balancing these clashing values, you know, at least rationally, and that's all it needs to be in order to get over the APA test. So the whole thing is now at the Supreme Court. I will tell you one thing that was interesting about the Second Circuit opinion. After it blasted the commission for being arbitrary as a matter of admin law, it then went on for another 5 pages and said, and by the way, let's make some observations about the First Amendment. We think, you know, if it somehow gets rational in an admin law sense, it's never going to be able to explain its way around the First Amendment. The FCC would not be able to, said the Second Circuit. There are too many First Amendment problems with this kind of regulation. I'm frankly a little surprised the court took this case, because I keep thinking that technology is going to move a lot of these problems anyway. But the court did take the case. There's some interest level up there, and I'm going to be fascinated to see what the court does, since we've got Republicans and Democrats in Congress and on the commission sort of really hyped up about indecency regulation. It'll be fascinating to see where the judges align in the Supreme Court on this. I really have no way of predicting. But as an admin law professor, some days of the week, it's going to be really fun to see if the FCC is deemed to be arbitrary, irrational, abuse of discretion, all that. I mean, agencies always need a little comeuppance, and it may be time.
Thank you all for the opportunity to be on this panel tonight. It's a fascinating mix of cases, and I'm going to speak about the Neguse v. Mukasey case, which is an asylum case, and it is very much a statutory interpretation case. And that being said, I thought it would be helpful to have this up in the background so I can refer back to it a few times as I sort of outline what some of the background, what the major arguments are in this case. So the Supreme Court next month will hear arguments about what's called the persecutor bar in the Immigration and Nationality Act. And it's a statutory provision that precludes the granting of asylum to a person who, here's the language, ordered, incited, assisted, or otherwise participated in the persecution of any person on account of race, religion, nationality, membership in a particular social group, or political opinion. And this provision was enacted as part of the Refugee Act of 1980, which is part of the broader Immigration and Nationality Act now. So the question presented to the court is whether this INA provision categorically excludes from eligibility for asylum any person who has been forced by threats of death or torture to assist or participate in a persecution. And as is true with a lot of immigration cases that go to the Supreme Court, again, it's just a statutory interpretation issue. And the question here is, does this language apply to involuntary acts of coerced conduct? So the facts in the Neguse case are pretty straightforward. There was the decades-long war between Ethiopia and Eritrea, and the Eritrean government during that time routinely rounded up its citizens and for national service, and military invaders were imprisoned, tortured, and sometimes even killed. So the petitioner in this case, Daniel Neguse, is an Eritrean citizen who was arrested at age 18. He was forced to perform hard labor, and then he was forced into military service. But he refused to go to the front because he was actually half Ethiopian, and he said to go to the front in this war would be like fighting his brothers. So as a consequence for this refusal, he was sent to a prison camp for almost 3 years, where he was also then persecuted for converting to Christianity. Upon his release from the prison camp, he was forced to serve as an armed prison guard, and he wasn't allowed to leave the base. So during his time as a prison guard, as opposed to just being a prisoner before that, Mr. Neguse's responsibility was to keep control over the other prisoners who were there primarily because of either their nationality or their religion. And so his job was to stand guard, to catch prisoners who were attempting to escape, to stand guard when they were kept out in the sun as a form of punishment and sometimes execution. And he was aware, he conceded that he was aware that a prisoner could die if left in the sun for more than 2 hours, but he concedes that he was forced to stand guard and watch over people who were left in the sun. And he was also responsible for keeping the prisoners, preventing them from taking showers, from obtaining ventilation or fresh air. So he witnessed torture taking place, but there's no evidence that he ever beat or killed any prisoners. So the question is sort of his level of participation is an issue. Now there's some evidence in the record of redemptive acts by Mr. Neguse. Occasionally he would refuse an order to punish a prisoner. Sometimes apparently he would take a prisoner out to get some fresh air in the middle of the night, and once in a while he would even sneak food, water, or cigarettes to the prisoners as a little bit of relief in their situation. And I suppose having been a prisoner for so long himself, he felt some degree of sympathy. So after 4 years as a prison guard, Mr. Neguse couldn't take it any longer. He fled, and he actually stowed away on a container ship and ended up in the United States. So once he got to the United States, he began the process of applying for asylum. And generally speaking, the 5 grounds for applying for asylum are that you've been persecuted on account of your race, religion, nationality, membership in a particular social group or political opinion. So you can see that's actually incorporated then into the persecutor bar. So the immigration judge who heard his case found that Mr. Neguse was credible, but he denied the asylum request because of this persecutor bar that you see behind me. And the immigration judge said that the very fact that he helped keep the prisoners in a compound where he knew they were being mistreated constitutes assisting for purposes of the statute, and that even though the immigration judge believed it was more likely than not that Mr. Neguse would be tortured if he were sent back to Eritrea, he denied him asylum. Now what he did grant was something called deferral of removal, which is a fallback procedure and something less, your rights are less. So in other words, this is a provision under the Convention Against Torture which says that the United States won't send Mr. Neguse back to Eritrea or any other country that would torture him. He's kind of in legal or an immigrant limbo, if you will, which is to say that he doesn't have any immigrant rights in the United States, and he can sort of stay for the meantime, but the U.S. has the right to maybe send him to a country that wouldn't torture him. And it's far short of being granted asylum rights. So he appealed this decision to the Board of Immigration Appeals and then to the Fifth Circuit after that. And both of those bodies dismissed his appeal and said that it's immaterial that he was compelled to be a guard because motivation and intent are irrelevant to issues of whether you assist under the statute. And the Fifth Circuit relied on its own precedent and followed a 1981 Supreme Court case that's called the Federico case. And the Federico case was based on a different statute in a different context. It's 30 years earlier. And the language is actually different. So one of the issues here is it right for them to be following the Federico precedent, or is this case distinct enough, and this statute distinct enough from that one, that there's some leeway to have a different interpretation. So just to give you a little bit of context quickly about the Federico case, there was, again, different language but similar purpose. There was a bar that involved the Displaced Persons Act of 1948, which was an act that enabled European refugees who were driven from their homeland after the war to immigrate to the United States. And in the Displaced Persons Act, they said that you were not a displaced person if you had either assisted the enemy in persecuting civilians or if you had voluntarily assisted the enemy forces in their operations. That's the statutory language, those two provisions. You can see that that's similar, but the language is different. So again, at issue here is this a proper standard to follow? And of course, the petitioner says that it's not. You're misplaced to rely on the Federico precedent because, again, it's a different context, it's a different statutory construction. And in the language I just quoted, which is not up here, from the Displaced Persons Act, you have one clause that says that you're ineligible to come to the United States if you assisted the enemy in persecuting civilians. And you have a second part in the provision that says, or if you voluntarily assisted the enemy forces. So the petitioner says there the provision had a clear distinction, that voluntary was used in one place and not in another. And here, the word voluntary doesn't appear at all. So we shouldn't rely on that to construe the meaning here. They also said that related to a specific context that is post-World War II, whereas the Refugee Act of 1980 was meant to address worldwide conflicts more broadly, and it was meant to give more discretion to the Attorney General. So this provision shouldn't be sort of restricted by the older provision that the Federico case relied on. Of course, the government says that it's proper to follow the Federico case, and that federal courts have followed it ever since 1981. And I think one really important point that the government makes is that this was enacted in 1980, as I mentioned before, it's part of the Refugee Act of 1980. Federico came in 1981, and this actual provision has been revisited and actually was reenacted in 1996, which is obviously well after the Federico case. So the government's saying, hey, Congress could have clarified in light of the Federico decision and tried to be clear about what they meant here, but they didn't. So therefore, they didn't want to make an exception to the persecutor bar that said that if you were coerced into this conduct, that it didn't apply to you. Of course, the other big argument between the two sides is what's the plain meaning of the statute? And the petitioner's arguing that the word persecution itself requires some element of purpose and intent, that you can't have involuntary persecution. And they point out that around the world there are a lot of examples of folks who are actually victims of persecution that have been forced to engage in persecution themselves, and that if you exclude these people from asylum, that doesn't really make sense. It's not that they're just following orders, they're actually under threat of death. So it is actually, if you're forced by threat to engage in persecutory acts, that itself is another form of persecution. You're just a victim. So, of course, the government's reply to that is, well, this statute is pretty clear. It doesn't say anything, there's no exception for persons acting involuntarily, there's no state of mind requirement. The bar turns entirely on conduct, not on motivation. And the very word persecution, of course, the government's perspective is it doesn't require any inquiry into your motivation. So they said that if Congress had wanted to, they could have put the word voluntary in there. And in fact, there are many other provisions of the INA that have a voluntary element to it. So the fact that they didn't, we're not going to read it into it, is what the government suggests. I'll sort of turn now to the significance of the case. There are many other arguments that are made in the briefs that are interesting, but just to sort of, what's the big picture? One is that I think we're likely to see this fact pattern arise in future asylum cases increasingly, and as the petitioner's brief emphasizes, we're seeing coerced participation in armed conflict in many countries throughout the world. So asylum officers at the lowest level need some guidance. What does the statute mean? Does it mean that I can't grant someone asylum if they were forced to do something? We need some clarity. We need to revisit the issue one way or the other. Human rights groups are obviously watching this case very closely because they feel that U.S. asylum laws need to be consistent with the international conventions that the U.S. has signed on to, and in fact that they feel that there needs to be an exception of the persecutor bar as there is in other countries in international law. And the government's response to that is that this is a reasonable implementation, domestic implementation of the international convention, and that it does comport with the overall purpose. So, yeah, just to quickly summarize, I was giving this some thought in the context of what the court has done. There have been several statutory interpretation cases specific to immigration law in the last decade or so. And in most of them, it seems like the court has been pretty literal and strict in the interpretation. And the only exception to that is if to be too literal will result in the statute being unconstitutional, which is not an argument being made here, or if it's to be too literal is to give too much. The government's going to apply the statute so broadly that it's almost a ludicrous result. So I think that probably, especially for the fact that Mr. Neguse has deferral of removal, he's not going to be removed back to Eritrea, so his life may not continue in the United States, but he's not actually going to be in danger in the outcome of this case. I strongly suspect that what the court will do is say, if Congress wanted an exception, they can put one in, and sorry, Mr. Neguse, but we're not going to read something into the statute that's not there, and kick it back to Congress. So that's the outcome that I'm looking for after the court hears this next month. Thank you.
I never thought to hear Brian Murchison speak so naturally in Paris Hilton. It's really the case I have to discuss, Wyatt versus Levine, is the kind of case that reminds me of why I keep meaning to teach a course on food and drug law. I was struck, actually, while listening to Brian, and I glanced ahead to double check and see what Michelle was talking about. I was struck by the administrative character of so many of these cases that are a significant term. And if the 20th century belonged to the common law, the 21st century appears destined for the agencies. And that's really what my case is about. Tort law has historically been a very substantial feature of drug safety regulation in the United States. Now, it needn't be. There's actually very little tort law in EU countries compared with the U.S., although some are quickly closing that gap. But the EU relies generally on administrative regulation to assure product safety. In the United States, FDA regulation actually followed fairly limited tort regulation, and then gradually began asserting itself as the predominant regulator of drug safety. And these assertions have become increasingly strong and may reach their zenith with the case of Wyatt versus Levine, which will be heard the day before the election. Now, this is one of those cases where each side does have something to work with, but I suspect that Wyatt and its amici have chosen wisely in capitalizing upon some recent Supreme Court rulings in this area. So the facts are tragic. Ms. Levine suffered terrible migraines that left her nauseated, and her clinic used a special IV procedure called IV push to inject her with medication manufactured by Wyatt. Now, for reasons that are a little bit unclear, but which strongly tend towards negligence on the part of the clinic, the medication found its way into Levine's arteries. Either they misinjected it, or it leaked from a vein into an artery. This case also reminds me of my pathological fear of needles. Because injecting medication into arteries, not veins, is extremely dangerous. It caused all the capillaries in her arm to shut down within about an hour. And eventually she suffered gangrene and amputation. She was also a musician. Now this is a hard case, as they say, but she faces some bad law. For historical reasons that are not too relevant here, pharmaceutical product liability cases are basically failure to warn cases. You don't argue, this drug sucks, just look at my arm for God's sake. Instead, you argue, if only my health provider had been given an adequate warning of the risks, either the provider would have acted differently, or I would have. So there. This is where things get interesting. There was a fairly extensive and explicit warning on the medication. It described the risks of intra-arterial injection, including necrosis, death of tissue, and amputation. It's very hard to read this warning and not call to mind the precise disaster that occurred. Moreover, Wyeth had suggested a different, maybe a stronger warning, but the FDA had rejected it. The labels you see on any prescriptions that you have, the package inserts, are specifically commanded by the FDA. The manufacturer cannot change them, subject to a possible exception I'll discuss in a second. So while Wyeth argued that its hands were tied, and that it simply could not have provided a stronger warning consistent with the FDA. A jury disagreed, so did the Vermont Supreme Court, and Levine was awarded $6.8 million. The clinic, by the way, settled for $700,000, and this once again illustrates the Willie Sutton at work. Now, the question that the Supreme Court is going to answer is whether the, quote, comprehensive FDA regulatory regime impliedly preempts state tort law. There are two basic types of preemption in pharmaceutical cases. Congress did not expressly preempt tort law for drug makers. It did so, however, for medical device makers. And last year, the Supreme Court confirmed that once a new medical device is FDA approved, state tort law cannot be used to challenge that by way of a liability judgment. Now, although there does not exist an express preemption provision for drugs, most of the arguments one might make, in fact, the arguments that the Supreme Court did make just last year on why express preemption is a great idea would apply equally. The regulatory regimes are quite similar. Drugs are heavily regulated. There are lots of studies and paperwork that are involved. The time and cost estimates for new drug approval do vary quite widely, but it's regarded widely as requiring hundreds of millions of dollars and a very lengthy process. More importantly, the FDA is supposed to look at all the stakeholders who might be affected by the decision to approve or not approve a new drug. Juries only see the injured plaintiff. Now, I spent a lot of time talking about the learned hand formula in my torts class. It's almost impossible for a single jury to get and correctly process complete information about all the risks and benefits. The FDA has a lot of limitations, but at least it is designed to weigh all the competing risks and benefits. For example, I read an amicus brief written, interestingly, by the plaintiff's father. There are 4 different ways of administering this medication, and in his view, and his daughter's, Wyeth simply recommended against IV push, the disastrous procedure here. Abstractly, that does sound reasonable to me. IV push clearly has risks the other methods don't. But there are some problems. For one thing, the clinic treating Levine did try one of the other methods, and it just didn't work. Moreover, the risk of warning people away from IV push is, from a public health standpoint, the risk that some people who should use it will not. The FDA does not want to discourage uses of medicines that it thinks are beneficial overall. while I might agree that patients and doctors are the ones to trust with risk-relevant information like this, the FDA as it exists today does not quite function in that way. It is trying to maximize public health welfare. I mentioned an exception. There's an FDA rule that was adopted several decades ago that permits drug makers to provide stronger warnings even without FDA approval. Levine and the Vermont Supreme Court thought that Wyeth's failure to do so first made Wyeth negligent, I mean, they should have done this, and two, undercut Wyeth's argument for preemption. After all, if you can do something anyway, where's the conflict with the FDA? The problem is that that rule, that exception, probably best read the way the FDA itself reads it, which is to govern newly discovered risks only. Otherwise, the following scenario is possible. On Monday, Wyeth asks the FDA for permission to change the label, and the FDA denies it. On Tuesday, Wyeth invokes the exception and goes ahead anyway. This is preposterous. For one thing, the FDA would react probably no later than Wednesday to compel Wyeth to put the label that they wanted the first time back on the product. The plaintiff would have more to work with here if Wyeth hadn't tried to do something about a long recognized risk. This risk of intra-arterial injection there's nothing new about it. It's been understood for decades. But on the facts here, the conflict between tort law and administrative law looks rather concrete, not theoretical. And imposing tort law standards for this kind of warning would plainly frustrate, in the lingo of implied preemption, the FDA's apparent intentions. This case, as Tony Seebach and Ben Sapersky from New York have suggested, is a poster child for tort reform, and they do not mean that as a compliment to tort reform. The warning was adequate and specific. And if I put that warning on the exam, the answer is no liability. It's a really strong warning. And the negligence that is at issue here appears to have come from the clinic, much more so than Wyeth. If there was ever a case in which a drug company would want to ask the Supreme Court, who are you going to trust, the experts at FDA or 12 morons on a jury, this is the case they would pick. The result will probably be closer than was the case last year in Regal. That's the case that involved medical devices. But I do expect the Supreme Court is going to vacate the Vermont Supreme Court decision. Now, if Levine is lucky, she'll have a chance to go back to court and criticize the FDA's handling of the warning issue. It's not quite clear that the FDA thought about that warning rejection very carefully. The FDA, like a lot of agencies, can be quite vague in describing the fit between what it wants to do and some broader social policy goal. The agencies often speak in conclusory ways. And if Levine is lucky, she'll have a chance to say, well, the FDA rejected that warning, but since they didn't think about it very carefully, this court shouldn't give too much deference to that. I don't think, however, she's going to get that chance. Thank you.
Well, good evening, everybody. If you read the program cover, you saw that our congenial hosts have touted tonight as a preview of the important cases that are pending in the Supreme Court of the United States. But by that standard, it is very difficult to understand why the seemingly sorry, sad sack opinion that I've been stuck with, the Sara versus Pocatello Education Association, made it onto tonight's program. In fact, I'll tell you, behind the scenes, the publicist for the law school, Peter Gitan, was here, and Peter sent out an invitation to the speakers to do little blurbs for the webpage of the law school on this case. And he asked everybody else, and few days go by, Peter never calls me. Never asks me, you know, Peter, what's the story? You haven't asked me for. I'm traveling. When are we going to do our recording? He said, nobody cares about your case. Nobody ever will care about it. It's not newsworthy. We just like to. If you have something else to do, you know, that night, go ahead. Indeed, the case is so mundane, so garden variety, so incredibly boring. Now, I'm going to use it not to explore the merits of obscure First Amendment doctrine, for which it ostensibly stands, but to explore the art of lawyering. So here is the question. How were the extraordinary lawyers who represent the state of Idaho in this case able to get the Supreme Court of the United States to grant certiorari? Now, some of this is sort of an automatic forced move, sort of like the opening moves in classic chess pieces. It's often the case that as a lawyer, you have to attempt to obtain an appeal from a court above the court that you are in, and the appeal is discretionary. This is commonplace. It happens throughout the legal system. It might be that you're in a justice of the peace court or a lower district court, and you want to get some opinion appealed to a circuit court in your state. Many states do not grant appeals as of right to the state Supreme Court. Here in Virginia, for example, you must convince the court, often in front of a 3-judge panel of the Supreme Court justices, to even hear your case. And of course, we all know that the hardest thing to do in the litigation system in the United States is to get the Supreme Court of the United States to take a case. And it gets harder and harder all the time. The Supreme Court takes fewer and fewer and fewer cases. The docket is ever shrinking. So when you are attempting to get an appellate court to take your case, and it's discretionary, in a situation, and this is true in many courts, but it's certainly true in the Supreme Court of the United States, you basically have two possible strategies. Indeed, the court itself tells you this in the court's own publications. Notwithstanding, the cultural cry, I'm going to fight you all the way to the Supreme Court of the United States, everybody loves to say it's a great kind of litigation cliche. In fact, as a practical matter, you have 99.999% of cases don't have any chance of ever reaching the Supreme Court. So you basically have two strategies. The classic strategy, the one that all the Supreme Court inside baseball seasoned advocates will tell you to do, is to show the court that there is a conflict among lower courts. And in most well-written petitions for certiorari, the petitioner tries to convince the court that there's a conflict. This often creates an ethical dilemma because you, as a lawyer, have to make the decision as to how much you can characterize and spin and shape both what your case stands for and what the cases that are allegedly in conflict with your case stands for, so that you're not caught in the unethical, unseemly position of conjuring up a false conflict and making it look as if there's a split between what Wyoming said and what New York said, when really in good conscience there isn't. All right. Now, in the poor Pocatello case, there's no hope of a conflict because no one ever passed a law like the state of Idaho passed, and there are no precedents that appear to be in conflict. And even if there were, they'd be so incredibly boring because this area is so dry, you couldn't pay attention long enough to even discern the conflict. And so the state of Idaho made no attempt in its papers to say that the reason you should take this case is because it conflicts with what Montana's done. All right? The next possibility is to convince the court that there's a substantial federal question, an important area of federal law, something of importance to society. And even though there may not be a conflict, it is important for the Supreme Court of the United States to resolve this for the good of the country, the good of the justice system, and so on. And if you were listening to the four cases that my colleagues elegantly just went through, you can see significant importance in all of them. Importance to the legal system, importance to our sense of justice, and so on. And so the cases had some ballast to them. But when I now describe to you the conflict that is posed by Yesursa versus Pocatello, I'll suggest that as you first listen to me, if you're able to to stay awake for a minute, you'll have a very hard time seeing why anyone would think this is cert-worthy. All right? Here's the case. Idaho passed a law, and actually the law is fairly aggressive. You can imagine the law having some juice to it in terms of litigation. The law, on its face, banned any employer within Idaho from setting up a system whereby employees could voluntarily, from their payroll check, send deductions to a political cause. So if I am an employee of Boise Cascade Timber Company, and I say to my employer, I'd like you to send $10 a month to the Obama campaign, or to the McCain campaign, or to the Idaho Republican Party, or Democratic Party, or Citizens Against Abortion, or Citizens in Favor of Environmental Reform, doesn't matter. This law would prevent me from doing it. It wouldn't allow the employer to set up the voluntary contribution system in the way that you set up contributions to United Way, for example. All right? Now, that's a sweeping law, and that would pose enormous, or as my 7-year-old likes to say, ginormous, First Amendment problems, except that the state of Idaho admitted the law was entirely unconstitutional as applied to the private sector. They confessed error, did not attempt to defend the law. Idaho just said, forget about it, and the law is clearly not enforceable and not enforced as to the private sector, where there would be serious First Amendment questions, because political activity is at the heart of the First Amendment, and for the government to step in and say that an employer and an employee could voluntarily bargain to set up this contribution system to make it a little easier for you to send your money, because you don't have to write a check. It doesn't hurt as much if you never really get it. It hurts a lot more if you get it, and then you've got to write the check and send it back out. All right? It's easier to be generous. And so if people wanted to do that in the private sector, they have a First Amendment right. So the case is already being narrowed into boring land. All right? It's being narrowed because Idaho only seeks to defend the law as applied to public employees. All right? And it's in that posture that the case is actually litigated in the Federal District Court in Idaho and then in the U.S. Court of Appeals for the Ninth Circuit. And both lower courts reached the same judgment. And it's a curious split decision. Split not among the judges, but split in terms of the winners and losers. What the Ninth Circuit decision holds is that it violates the First Amendment to apply this law to local employees, to employees of the city of Boise or Pocatello or a local school board or a local county. That violates the First Amendment because of the application of an obscure but important area of First Amendment law known as public forum law. However, the Ninth Circuit says the law is okay, it is constitutional, as applied to Idaho's actual state employees. So if your check comes from the state of Idaho, you work for the Department of Motor Vehicles or the prison system or the governor's office, you can have no $10 deduction for Obama or McCain. But if your check comes from the Pocatello public school system, then they have a right to work with you to set up the system. All right? Now, what could possibly be the legal theories behind this distinction? The Ninth Circuit says that as to state employees, we're going to apply what's known as the subsidy doctrine. Now, I actually didn't know it was known by that, but you learn something new every day. All right, but it's a fairly logical and fairly well understood First Amendment principle. The idea is that while the government can't restrict your political activity, it has no obligation to subsidize it. And there are a variety of Supreme Court cases that have upheld a whole series of laws, many of them federal laws, many of them tax laws, that do not create a government subsidy for the exercise of political activity. The most controversial of these laws are the laws that make it impermissible for most charities to engage in political activity. So, for example, the preachers can't endorse one of the presidential candidates from the pulpit on fear of losing their 501c3 exemption. Right section, Michelle? I had that right? Okay. All right. And my taxes are due tomorrow. What are you doing tonight? They are. It's October 15th tomorrow, man. I'm in a heap of trouble. We got to get this over. All right. So that concept that you don't have to subsidize political activity, the Ninth Circuit says, means because it's a hassle to set up this deduction system, because you got to spend money creating the computer codes, writing the checks differently, segregating the funds, sending the funds to the political campaign. It's going to take accountant, time. It's going to take administrative time because there's effort and expense involved in creating the political contribution system. That's a kind of subsidy. And Idaho has the right to say we're not going to spend our precious state dollars subsidizing people engaged in the political process. That's your problem. We're not going to pay for it. The Ninth Circuit says, so you guys win. The state of Idaho wins. But the court reasons, if the school board decides to do it, or the city of Boise decides to do it, it's not the state's money. You're not subsidizing the political activity. It's the decision of the municipality or the county or the local agency that's doing it. And therefore, you can't use the subsidy doctrine to justify that restriction. The court then says that we think of these decisions by localities to either allow or not allow deductions from payroll checks for various things as a kind of public forum. Now, I'm not going to go into all of public forum law, but the basic concept is that the government has certain physical spaces, like parks and streets, or auditoria, or other locations, the plazas of universities, and also sometimes programmatic operations that are arenas for freedom of expression. So the government has created places and spaces and programs where people can engage in political activity or other expressive activity. And that's called a public forum. There are a lot of different kinds of public forums, but we don't need to get into that for our purposes tonight. And once you create a public forum, an important First Amendment principle kicks in. You're not allowed to discriminate on the basis of the content or the viewpoint of the speech within the public forum. So you don't have to create the forum in all situations, but once you do, you're required to be neutral in your regulation to it. And so what the Ninth Circuit says is we think that because a lot of municipalities do allow deductions for various things, you can send money to the Boy Scouts or United Way or whatever it is through your paycheck system, that in large it's a kind of public forum that exists within the state. And for Idaho to come in and ban political activity deeply offends the First Amendment, because after all, that's the most important kind of speech there is, the court says. All right? Now, that's it. That's the case. Now, who the hell cares? I mean, it's public forum law. It's a mundane, garden variety, routine application of public forum law. Maybe the Ninth Circuit got it right. Maybe the Ninth Circuit got it wrong. But how on earth are you going to get the Supreme Court of the United States to take this case? Public forum law is well established. Who the heck cares whether the city of Boise's payroll deduction plan is or isn't the public forum? That's not like asylum and stuff, you know? It's not like Nipplegate, you know? I mean, it's... All right. So here's the lesson in lawyering. When you're a lawyer and you lose on seemingly mundane grounds, if you can, what your key to success is figuring out a brilliant theory for taking what seems like a run-of-the-mill case and making it look gigantic, making it look profound and deep and important. All right? So what was the stroke of genius that the Idaho Attorney General's office came up with? Now I want to tell you, as I thought about how it was they were so smart, I began to think about Idaho. And I think that the key lies to some degree in the culture of the state. When I talk about Idaho, I know you're going to say, oh, it's potatoes, you know, or it's the blue football field that Boise State plays on, right? But, you know, or the beauty, the incredible beauty of the panhandle that stretches up north of Coeur d'Alene, up to Glacier National Park in that area, right? But if you think about Idaho, and you think about it in conjunction with where our visiting colleague Eric Luna is from, Utah, and you think of the United States stretching through the Dakota, Dakotas and Montana and Idaho and Wyoming and Colorado and Utah, and you've got the backbone of a fierce streak of defiant anti-federal government independence, right? This is where the Wobblies were from. This is where the tough miners were from. This is where the ranchers that don't like environmentalism is from. This is that streak, right? This is that streak of get off our backs, federal government. We're states. We're sovereign. This is our decision. This is none of your business, right? You see that all over the country, but you see it in the Rocky Mountains as much as anywhere in the whole United States. And that was the brilliance of the argument. Instead of treating this as a routine public forum law case, which would have been a sleeper, they made this into a federalism case. And they posed it as a gigantic clash between two giant constitutional concepts, federalism and public forum law. All right? Federalism in the First Amendment. And here's the argument. Idaho said, you know, in the national scheme, the states have sovereignty. They have sovereignty in the very structure of the Constitution. They have sovereignty under the 10th Amendment. And there are things the federal government can't do to the states without violating the inviolable sovereignty of the states. But Idaho said, guess what? There's no similar rule internal to any given state. That is to say, Boise has no sovereignty, no 10th Amendment style sovereignty vis-a-vis Idaho. Pocatello has no solidity to it as against the state of Idaho in the same sense that Idaho has solidity to it as against the federal government. We don't even have to have cities. We don't even have to have local school boards. They're creatures of the state. We can organize our internal state government any damn way we want. Look at Nebraska only has one house in the legislature. And that doesn't violate any federal constitutional norm. Therefore, when you, the Ninth Circuit, you liberal California overload Ninth Circuit, I think I saw that in the brief. I have to go back and check that. When you start pushing us around and telling us how we have to organize our state government, you're violating our sovereignty within the federal system. And we have the right to decide what all public employees within Idaho will be able to do or not do. And we can issue an order to Boise and to Boise controllers and to Boise employees just like we can to the people running the state itself. I'll end with a little story, because the brilliance of that and turning that into a big case is obviously what caught the Supreme Court's attention. And if the case has any traction, it'll be that. Here's the story, and then we'll end. It's a story about Lyndon Johnson visiting Vietnam, height of the Vietnam War. And he is there, and he's been inspecting the troops. And he flew in, not with Air Force One, but using military transport. And he spends time in Vietnam, touring the battlefields, and he's about to leave. So he's at the tarmac at an airport in Saigon, and there's a young Marine whose job it is to direct the president and the president's entourage to the plane that the president was to take to leave the country. And so this nervous young Marine is leading the president's entourage, and suddenly, in the middle of the tarmac, stops, frozen, and his face becomes ashen. He realizes he has taken the president the wrong direction toward the wrong plane. He turns around and sort of stammers, Mr. President, I apologize. This is not your airplane. And Lyndon Johnson looks at him, and he smiles. He says, that's all right, son. They're all my airplanes. That's Idaho's argument. It's all